that being said, they did ask that I give you guys a few disclaimers. Even though I'm an attorney, you are not my clients, blah, 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 blah. I'm going to talk about some complicated issues that are way too detailed to get into during this presentation. It's really imperative that if you guys want to create a trust, you talk to an attorney in your state. I would recommend an elder law attorney because those are typically the people who have the most expertise in this area. And also, I'm not going to talk about tax consequences of trusts at all in this presentation. That's really far afield. So moving on, in order to understand which trusts are acceptable and which are not, and that's another caveat, I'm only talking about what's acceptable under the federal Medicaid rules because each state administers Medicaid differently. Each state might have some of their own nuances in interpreting federal statute and some additional parameters around what they will and won't accept. But this focuses on federal law. So federally, what does Medicaid really care about? And in short, Medicaid cares about assets that are available to each applicant for the program. So let's begin by talking about income. Indiana defines income as the gain or benefit, earned or unearned, which is received or is available. And income is considered available when it's actually received and when the individual has the ability to make the income available. So that's technical, but basically, if you have the money or you have legal title to the money, then it's considered available to you. Here are a few examples. Throughout the presentation, I refer to this fictional guy, Al, in hope that it would kind of be a real-world example. So Al has 4 sources of income. His full-time job, royalties from his best-selling autobiography, rental income from farmland. You can tell I live in Indiana that we care about farmland, and repayments from a loan that Al gave to his daughter. So Al's salary income is considered earned income, obviously, and that's available to him when he receives it. Royalties are also available income when received, as is rental income from the farmland. Now, loan repayments get a little bit tricky, even though that Al has an expectation that he will be fully repaid. Only the income that Al actually receives is considered countable income. And when you get these slides, I do a little more breakdown in the notes section, talking about earned versus unearned income. So that might be helpful, but I think, again, that gets into the weeds more than we need for purposes of this presentation. So in addition to income, Medicaid looks at resources. In Indiana, resources are real or personal property owned solely or jointly by an individual. Resources are available if the owner has the unrestricted right, authority, or legal ability to liquidate or dispose of the property or his shares of the property. That is important when it comes to joint bank accounts and that kind of thing. Again, resources must be available in order to be counted in the eligibility determination. So to understand that, let's return to Al. Al has 6 resources: a house, 3 cars, checking account, savings account, 200 acres of farmland, and a prepaid funeral agreement. Some of these are real property, like the 200 acres of farmland, while others are considered personal property, the checkings and savings account. Again, I discussed that in the notes, but I don't think we need to get into that. What's also important to note is that under Medicaid, certain resources may be exempt. For example, the house of an applicant or beneficiary is considered exempt if the individual is still living there, or if he or she plans to return there, say if they're in a nursing home for a while. 1 car usually is considered exempt if the person uses the car to get to and from medical appointments. You can have money in a checking or savings account so long as you don't have more than $2,000 in that account. And again, another caveat, that's absent having a past plan or something else that would bump that up. And then usually prepaid funeral agreements also are exempt resources. So Al may be able to get by, maybe not. The farmland is probably a problem, and the 2 cars that he wouldn't use for medical transport are a problem as well, potentially. So what happens when an individual has resources over the limit? Well, they will try to get rid of those resources. Medicaid knows that. So they have something called a 5-year look-back period. And that means that Medicaid will go back 5 years from a certain date. And with older people, this is usually the date that they were first put in a nursing home. But the beginning date varies. But basically, the state will look back 5 years. And if resources were transferred for less than fair market value during that period, a transfer penalty can be imposed by the state. During a penalty, a Medicaid beneficiary will not be eligible for certain Medicaid services. Unfortunately, those services are nursing home services and home and community-based services, the ones we care about the most. And there is a way that transfer penalty is calculated. It's based on the rate of a nursing home per month, and it's complicated. If you want me to talk about it further, I can, but I don't think we need to for this presentation. I bring it up to say only that you need to be really careful not to give away your resources to other people or turn away resources or income that you are owed, because it can come back to bite you pretty badly. And it's also important to note that some transfers of assets are exempt from penalty. So let's say that Al goes into a nursing home and he has, well, I think in my next slide, I provide some examples. Sorry about that. But examples are transferring a home to a disabled child or transferring assets to certain trusts, which is the subject of this presentation. So yeah, the Al example. Let's say that in 2007, Al quits his job and moves into a nursing home. He transfers his home to his daughter who has a disability. Like we said, that's okay. He will not be penalized for that. And this is assuming that the look-back date is when he applies for Medicaid rather than moves into the nursing home. Al sells his 3 cars for Blue Book value. that is permissible because he got fair market value for those cars. Al gives his farmland to his brother. Mistake. Al's going to get penalized for that. Al no longer receives loan repayments from his daughter, and his book sales have been discontinued, so we don't need to worry about them. Al runs out of money, and Al applies for Medicaid. So, like we said, the farmland transfer is going to be a problem. Trusts. Those are a way that individuals can transfer money and get away with it, basically. First, I want to talk to you about special needs trusts. I think that's what everyone here is probably most interested in. There are several statutory requirements for creating a special needs trust with your own money. First, a Medicaid applicant or beneficiary must be under 65 years of age, and they must be disabled as defined by statute. The trust must be for the sole benefit of the applicant or beneficiary to Medicaid. So that means the person who's on Medicaid is the only, or who is applying for Medicaid, is the only person who can benefit or receive anything from that trust. Settled is a word that we use in legalese for created. So the trust has to be settled by a parent, grandparent, guardian, or court. That is important because it means you cannot create a special needs trust for yourself. Someone else is going to have to sign off on it for you. And maybe the biggest bummer of all is that a special needs trust must repay the state upon the death of the beneficiary in an amount up to the total medical assistance paid on behalf of the Medicaid applicant or beneficiary. So that means if when you die, your special needs trust has $10,000 and Medicaid spent $8,000 on you, you would have to pay that $8,000 back to the state. I want to talk a little bit about the pros and cons of setting up a special needs trust. First, you can choose your own trustee, although you cannot be the trustee. I don't know how familiar you guys are with the concept of a trustee. Hold on, I'm going to get a drink real quick. Sorry. Okay. So a trustee is the person that manages the trust. They're the ones who will take money out of it, put money into it. Money coming out of a trust is known as a disbursement. So the trustee is the person who disperses trust funds. If you choose a friend or relative to be your trustee, they might not charge you administrative fees, whereas if you opt for a bank to be your trustee, they often won't charge you a set amount to comply with the terms of the trust, do their accounting work, and all of that stuff. What I think is the biggest pro of a special needs trust is that you have the ability to draft a trust agreement yourself in conjunction with an attorney, and you can draft that with wide latitude in what your trustee can use money towards. So although your trust will say that disbursements are to be made at the discretion of the trustee, meaning the trustee gets to decide whether money comes out of the trust or not. Okay. Could everyone mute themselves, please? I'm hearing some static noise. Thank you. So, disbursements are made at the discretion of the trustee, meaning that they decide what comes out of the trust. But you can put in the trust agreement that it is okay and it is advisable, it is strongly suggested that the trustee make disbursements for the things that you really want to use the trust for. You can have the trustee, at their discretion, make disbursements for vacations, for education, for entertainment, and you can make very clear in your trust agreement what your intent is and how you want the money dispersed for your benefit. Now, for the cons of special needs trusts, like I said, someone else has to settle the trust on your behalf. That's kind of paternalistic. You have to get someone else involved. A special needs trust, like we said, can't be established once an individual reaches the age of 65. So if you end up working until you're 67 and then decide to retire and want to put all of your retirement savings in the trust, you can't do that. Another important concern is that if any of your assets are commingled with the assets of another, those assets may be roped in to your assets and then have to repay the state for your medical expenses. So let's say that you set up one of these trusts and you put $10,000 into it. Then your uncle dies and puts $5,000 into it. If you cannot show that those two income sources are separate and are treated separately, then when you die, if you owe the state $50,000, chances are they're going to take the whole thing. Whereas if your uncle's money had been kept separate, then it might not have had to go to repay the state for your medical expenses. Okay, that's special needs trusts. Oh, yeah, let's talk about Al. So, you remember that he had that farmland that he gave to his brother. If Al had put the farmland into a special needs trust, assuming he was under 65 years of age, he wouldn't have gotten a transfer penalty. Moreover, if the trust had continued to rent out the farmland, income that was generated would be paid to the trust and could be used for Al's benefit. So Al no longer has income since he gave away the land to his brother, and he is undergoing a transfer penalty. So it's important to be careful and know that you can put assets into a special needs trust, even real property. Pool trusts. Pool trusts are kind of like special needs trusts with a couple of differences. In a pool trust, an individual also needs to be disabled under the same definition as under a special needs trust, but they don't have that 65 under 65 year of age requirement. In this kind of trust, a nonprofit organization serves as trustee, and they keep a separate sub-account of a master trust for each beneficiary. This kind of trust can be settled by a parent, grandparent, guardian court, or by the beneficiary. So if you wanted to create a pooled trust, you could go out and do it without anyone else's help, other than obviously the nonprofit organization. The interesting thing about these kind of trusts is that when you die, if you have one of these things, the nonprofit organization gets to keep 50% of the assets in your trust, and then the remainder will go to repay the state. I don't know if you guys are familiar with the ARC, but they run a pooled trust that's pretty popular. There's also an organization, I think it's called something like Special Needs Integrity, and I've seen a couple of their trusts as well. So the pros and cons of pooled trusts. As I mentioned, the nonprofit serves as trustee, so you don't have to worry about finding a trustee yourself. Also, the nonprofit has experience doing this, so they know what they're doing. You don't have to worry so much that they're going to screw up. And then when you die, another benefit is that some of your money gets to go to benefit the nonprofit. So you don't feel like the state is taking everything. You get to do some good work with your money when you die. I personally would not want a pooled trust because I don't like that I don't get to choose who the trustee is. I don't like that I can't get rid of them if they're messing up. Well, you could get rid of a pooled trustee, but it would take a lot more effort and litigation, I think, than if you had your own trustee. I don't like the anonymity that's involved there. The terms of the trust are pre-drafted. The way it works is that they have a joinder agreement that you will sign, and the trust agreement itself is already written. So you have a lot less control over deciding what types of goods and activities money can be withdrawn to pay for. There are often preset administrative fees, so money will be taken out of your trust to cover those costs. There's also often a cost in getting one of these trusts established. And even though the state only takes 50% of the remainder, that still makes it unlikely that friends and family would receive assets upon your death. So, back to Al. If Al was older than 65, in our example, meaning that he could not create a special needs trust, he could still put that farmland in a pooled trust. This, again, would have allowed him to escape a transfer penalty. Now to the final kind of special trust under Medicaid regulations, which is known as the Qualified Income Trust. I don't know if you guys are familiar with Miller Trusts. This is the same thing by a different name. The Qualified Income Trust is the only type of trust designed for income. You can't put any resources in a qualified income trust. Let me back up a minute and tell you how these came into being, and maybe that will make a little bit more sense. In Colorado, there were 4 women who had too much income to qualify for Medicaid based on retirement and that kind of thing. But they didn't have enough money to pay for a nursing home each month. So they were kind of between a rock and a hard place. So a court in Colorado said that family members of these women could create a trust, and income that was in excess of the Medicaid eligibility threshold would go into the trust, and then it wouldn't be available to the women anymore. One of the ladies' names was Miller, That's why these are called Miller trusts. So typically when we see these, we're talking about pension, Social Security, usually income that older people, retirees would have, although that doesn't have to be the case. And then again, when the individual dies, their money must repay the state up to the total amount of medical assistance paid on behalf of the beneficiary. Pros and cons. Like I said, this is the only type of trust specifically designed for income. Assets are used for what's known as post-eligibility budgeting expenses. These are things like unpaid medical bills. But trusts are a post-eligibility budgeting expense. So theoretically, at least in Indiana, an individual may be able to funnel assets from one of these trusts into a special needs trust. So let's say you were working and you didn't like the Medicaid buy-in program. I've seen it where the person put money over the income threshold into a qualified income trust and then funneled it directly each month into a special needs trust. I would definitely talk to a private attorney about this because it's rare, and I'm feeling that some states might have regulations around this, but it's an idea to put out there. Qualified income trusts are easy to settle. Many states, including Indiana, have trust templates on their websites. So all you do is put in your name, put in your income that you want to go into the trust, go down to the bank and set it up. There are also some states that allow people to serve as their own trustee. Indiana's not one of these, but you might want to explore whether your state allows that. Now for the cons. Accidentally including anything other than income of the applicant beneficiary will disqualify the trust. So if Al put his farmland into one of these, the trust is no longer worthy of receiving special consideration under Medicaid, and all of those assets would be countable. Also, the income can only be of the applicant beneficiary, so you couldn't put income of a spouse into one of these things. Again, because eligibility expenses are used for post-eligibility budgeting expenses, unpaid medical bills, nursing home liability payments, the applicant or beneficiary cannot use the trust for discretionary purchases. So no cars, no vacations, none of that stuff with a QIT. And then, as I mentioned, these kinds of trusts have to repay the state upon the individual's death. So back to Al. We know that Al quit his job before going into the nursing home. Did he receive a pension, Social Security? Does he want to write another bestseller and receive more royalties? If he does, this is the kind of thing that can go into a QIT to reduce his countable income and potentially make him eligible for the Medicaid program. The caveat is, remember, income that is available to the individual is countable. So although a trust won't be considered an available resource, the trusts could create income countable to the beneficiary under Medicaid income rules. I have a couple of examples. If a special needs trust paid Al $5,000 so that he could purchase new clothing, Al would be deemed to have received $5,000 in countable income. Why? Because the money went directly to Al. Al could do anything he wanted with that money, include pay for services that Medicaid is paying for. So $5,000 directly to the individual would be considered countable income. And if you receive $5,000 in a month, chances are that's going to disqualify you from Medicaid. Now, if the same trust paid the same $5,000 amount to a hospital to cover unpaid medical expenses of Al, that would not be considered countable income. Why? Al, it's not available to Al. It goes directly to the hospital. Therefore, he's safe. So the moral of this slide is don't receive the money directly. Have the trustee pay whatever you want to pay for directly without going through you. Okay, I think we're about halfway done, but if you're bearing with me so far, we've gotten through the hard stuff. What we talked about were the 3 types of trusts that receive special consideration.
Emily,
Yeah.
sorry to interrupt.
Yes.
You're doing a wonderful job. I've been monitoring the stress. I mean, not the stress, the chat. I'm calling it the stress. But anyway, I just want to say you're doing a great job. I don't know if you feel, do you want to power through, or would you like to answer some questions up to this point?
Let's pause for questions so I can catch my breath.
I think that's a really good idea. So what you're going to do is you're going to unshare your presentation for a second, and then we're all going to be up on the screen again. And I am going, now if you have everyone, I'm going to let you unmute yourselves to ask questions. You can also go in and you can raise your hand, which is kind of cool. You can raise your hand, and I don't know if you can see that. Can you see that? It's under participants or manage participants or something like that. But you can raise your hand virtually. And so if you do that, I will unmic you so you can ask your question. And then that's that. Does anybody have any questions for Emily at this point in time? Carlos Mitchell. All right. I think I'm okay.
All right, cool. So I know a lot of these trusts involve a parent setting them up. What if your parent will not set up a trust?
One option would be to go to a court. If you have a lawyer petition the court, they can write an order establishing the trust.
Okay. All right.
And then that's for the special needs trust. If you have a pooled trust, that's one that you can set up on your own. So is a qualified income trust.
Okay. Even if your sole income is SSI or SSDI?
Yeah, it doesn't matter.
Okay. All right, cool.
Oh, all right, thank you, Carlos. Anybody else would like to raise? Oh, I see a hand. I see a hand. It's Jeff Hoffman. Oh, and the Watson brothers. Oh boy, who did it first though? I didn't catch who did it first. I guess I'll let Jeff do it. And all right, and then we'll go to the Watson brothers.
Hey guys, can you hear me?
Yeah.
All right, cool. So my question is, how much, I asked a joking question in the chat about can you use special needs trust to hire strippers? And, it's an edgy question, but I think it gets to the point of how much discretion do we have in how this money is spent? Is there some kind of moral authority that controls this, or as long as it's not a Medicaid expense, are we good to go?
No, I think that your lawyer could draft a term saying that that the trust is to be used for health expenses including sexual health expenses. And it will be at the discretion of the trustee whether he or she will take the money out to pay a stripper.
Right, okay.
But Medicaid, they can't say whether it's okay or not. It's for your benefit. I think that your attorney could couch it in terms of health. So who is Medicaid to say whether one aspect of health is more worthy than another?
Right, okay. Just as long as the trustee pays the stripper directly.
Yeah.
Otherwise, it comes to me. Okay, awesome. I had another question that might be something to save for later, but you had mentioned this idea of funneling resources from a qualified income trust into a special needs trust, and that kind of caught my ear because what I discovered when you mentioned qualified income trusts, I looked into it, and my initial research led me to think that you, like, for example, my SSDI check is like $2,500 a month. I would have to put either all of that into the QIT or none of it. I can't split it and do like, 1,000 into the QIT and not.
That depends on your state.
Okay, it might be in North Carolina then that I ran into that.
In Indiana, you could split.
Okay, I gotcha. So my thought was, well, if I have to put it all in there, that might not be so bad if I could find a way to funnel it into a special needs trust. So anyways, that might be something we talk about later.
Yeah, that's not something that I can help with, but
okay.
I would definitely recommend talking with a good elder lawyer about it.
Awesome.
Thank you. All right, I'm going to answer. I want to keep moderating. I know we said we'd go to the chat box for some of these questions as well. So I'm going to let the Watson brothers ask their question, and then I'm going to go to the chat box and find a couple questions out of there because I want people to feel like they're getting their answers as well from there. So I'm going to mute you, Jeff, and or maybe Jeff already muted himself. Jeff, did you? Yeah, he already muted himself. All right, you're getting unmuted, Watson brothers. Hit it.
Yeah, actually, one thing I was just going to say regarding Jeff's question about the strippers and figuring out what's eligible or the discretion. I talked to an elder lawyer one time about that kind of thing. He basically said that he's the term quality of life. He basically said that anything that you could consider that would improve your quality of life can pretty much be argued to be, something that the trust can cover. So,
Blake, you're kind of quiet.
Okay, yeah, it's because my microphone's far away from me because we're trying to share. Maybe I'll just yell. Can you hear me?
A little better.
Okay. Anyway, Jeff already asked the question that we were going to ask, which was about how to funnel funds from a income trust to a special needs trust. So that was the same question we were going to ask. So I think we're good.
Okay. Well, thank you very much.
Right.
Do you have anything to say, Emily?
No.
Okay.
I would just say that I've seen it once. So yeah, it's tough finding attorneys who know this stuff. So if you talk to one and they say that they don't know, I would keep shopping around till you find the right person. There are probably 5 attorneys in Indiana who do this privately and are really good at it. So yeah, I think if you find a good one, they should be able to help with that, depending on what your state's particular rules are.
Can you talk a little bit about spouses and how they factor in this? Like, how's Al's wife? What's happening with her?
Well, in this presentation, Al does not have a wife
Is there
because that complicates things a lot. Yeah. spouses are tough to talk about because then a million other Medicaid rules are implicated. Do you have a specific question about how a spouse would affect a particular thing?
Well, we have some questions about like life insurance with a partner, like being on somebody's policy and their life insurance policy. We had another one. I thought it was going to be easy going through the chat, but man, okay. Let's see. If you have a joint bank account, how much of that account counts as a resource?
In Indiana, if you have a joint bank account with one other person, then the way the Medicaid office usually does it is they divide the account in half. Although technically, if a person has access to the whole thing, they could consider the whole thing. Are you still there, other Emily?
I am. I'm sorry.
Okay.
Okay, let's see. I'm sorry. I'm just going to the chat and it's like, it's complicated. Okay. People are complimenting you.
Thank you.
I'm so sorry, you guys. I'm trying to get to your questions, but every time somebody types, it like, okay. Let's see. I have a question. All right, here's the question. So I guess I'm confused. Sylvia asked, I have a question. I'm on a Medicaid waiver. If I sell my house, do I owe anything to Medicaid, or can I get a waiver for a few months until I buy a new house? Thanks. So I think that has to do not with this topic, right?
No, that's more having to do with the accountability of resources. And the brief answer to that is it depends. It depends on whether the money would be used to buy a new house, or what's going on with it.
Okay. Let's see. My camera's all screwed up. All right, if Al's farmland has a mortgage on it, could it still be transferred into the trust?
That's outside the scope. That gets into complicated things.
It's okay. All right, I have another question. This is my question. So my dad, I'm the only child, and my dad is not dying yet. He's in good health. He's going strong. But in the event that he dies, he's going to leave me everything. But I told him that I did not want to lose everything if he leaves me everything. So we have a family friend who is a lawyer, and he's a guy that we feel comfortable with and trust. And so my dad was thinking, instead of going through the formal trust thing, just to leave the guy the money with the understanding that he will be my basically informal trustee, and and I just have him like pay off stuff or do whatever, he would be kind of in charge of it. I realize that that's always scary when you leave money to somebody, but we feel very strongly that he's not going to do anything other than abide by my wishes. Is that a bad thing?
I'm going to talk about that in the next part of my presentation. But my question would be, what happens then when the family friend dies?
Yeah. Good. Yeah. Okay.
So yeah, I'll give you another option in the next part of the presentation.
All right. If anyone has anything absolutely needed to be asked, could you raise your hand now? For now or for the rest of the presentation, hold your peace. Okay. I don't think I'm seeing any raised hands.
Okay,
Oh,
let
wait,
me.
wait. The Watson brothers, your hand is up. Oh boy. All right. Okay.
Yeah, and again, I don't know how on topic this is. Can you hear me?
Yeah.
If you can get a little closer, that'd be great.
I'll try to pull up. I'm not sure how on topic this is, but we were talking about spouses. So just wondered, and there was a little bit of talk in the comments about the community spouse resource allowance, where the spouse's income doesn't count toward anything. So have you heard about that? It's called the Impoverishment Act. It's also called the Community Resource or the Community Spouse Resource Allowance.
Yeah, that's part of the MCCA, and that's super complicated. We could do a whole nother presentation on that.
Well, good.
I'll be there when we have that presentation.
All right. And then Alana says the Special Needs Alliance used to be a good resource for finding an attorney, but it seems like few attorneys are members. Is there a good nationwide directory of qualified attorneys?
There is a group called NALA. It stands for the National Association of Elder Law Attorneys. All of the good attorneys that I know in this area are members of that. So I think that might be a good place to go.
Can you tell me the name of it one more time?
Yeah, it's called NAELA, NAELA.
So
And
national.
It stands for National Association of Elder Law Attorneys.
Oh, thank you, Jeff. Okay, I just clicked it all for nothing. Okay, so let's continue. I'm going to mute everybody again, or everyone I think is muted right now except for me, my big mouth. And if you want to go and share your screen, and we'll finish up the second half, the Jerry's Kid portion, which I love that.
No spoilers.
I know, it's so good though. Okay, all right. So if you want to share your screen.
Yeah. Okay. So, in the first part of the presentation, we talked about trusts that statutorily receive special consideration under federal Medicaid statute. Now we're going to talk about some other kinds of trusts that they aren't considered special, but they do exist and they will impact Medicaid. Sorry, the slide is a little screwed up, but there are two basic types of trust overall: revocable trusts and irrevocable trusts. A revocable trust is one where the grantor, that is the person who creates the trust, the grantor is free to take money out of the trust. The grantor can amend or terminate the trust as he or she wishes. So basically, the person who creates the trust has full authority to do whatever they want, generally speaking, with a revocable trust. In an irrevocable trust, once money goes in, generally, the person who created the trust can't take it back out unless the trust agreement explicitly says so. That person usually also cannot change the terms of the trust or decide to terminate it before the termination date set out in the trust agreement. And that is important to know because of availability issues. But another thing that we have to add as background, Medicaid will consider revocable and irrevocable trusts created during the eligibility process, meaning by eligibility process, I just mean when Medicaid is determining whether to determining whether someone is eligible for Medicaid or not. So anyway, if an irrevocable or revocable trust, basically that means any trust when we consider them together, if it's created using resources of the person, or if it's if it's created by that person, by that person's spouse for their benefit, or by any person, including a court, acting on behalf of that person, Medicaid will care about it. Medicaid does not care why the trust was established, nor whether the trustee has discretion to make distributions only under limited circumstances. So I think that brings us back to Al. No, not yet. Back to availability. So in the case of a revocable trust, and I pulled this directly from statute, it is legalese. I tried to edit it to make it less confusing, but if it's still confusing, hopefully it will become more sensical once we go back to Al. But basically, if you have a revocable trust, remember that's the one where money can come in and out fairly freely. The assets in the trust are considered available to the individual if, they're considered available to the individual if payments can be made to or for the benefit of the individual. Sorry, I'm getting really tired. Anyway, all of the assets in a revocable trust are available to the individual, period. Now, payments from the trust. If they go to the individual, they're considered income. If they go to someone else, say your sister, then those are considered transferred assets. And we have to worry again then about transfer penalties. So in the case of a revocable trust, if there are any circumstances under which the assets of the trust could be used to benefit the individual, that portion will be considered a resource to the individual. And then as far as the income side of things go, if it goes to or for the benefit of the individual, it's considered income to that individual, and for any other purpose, again, transferred resource. So, examples. Remember that Al had 3 cars. Let's say that when Al sold his cars, he put the money into a trust. The trust said that Al could use the money for anything he wanted and could terminate the trust at any time. If you are following with me, you should know that that was a revocable trust that Al created. And because he can take the money in and out, it's considered available to him. It is a resource. Now, instead, let's say that Al, when he sold his cars, put the money in a trust that he could not terminate. So Al can't get the money out early. And the terms of the trust say that Al can only use the trust to buy new cars for his daughter. That's a revocable trust. That's an irrevocable trust. So it's not considered available to Al. There are no circumstances under which Al could use that money for his benefit. They can only benefit his daughter. If Al pays money out of the trust to buy a new car for his daughter, that money will be considered transferred, and Al would be penalized for that. So the reason why we say that special needs trusts, pooled trusts, and qualified income trusts are receiving special Medicaid consideration is because those trusts are irrevocable. So ordinarily, they would be considered transferred resources, not available to the individual. They still are considered unavailable to the individual, but they are not transfer penalty inducing. Testamentary trusts. This is what Emily was asking about. A testamentary trust just means a trust created by will. So there are special rules concerning testamentary transfers by spouses. So let's say a wife receives Medicaid and her husband dies and leaves her money. There are special rules. Those, again, are outside the scope of this presentation. I could touch on it a little bit if you're interested. Otherwise, I'll leave it alone. But basically, spouses aside, if someone leaves you assets in their will, those assets are going to be considered available to you. If you receive the assets outright, obviously they're available, but don't try to turn the money away. Remember when we were talking about availability, any money that you have the legal right to. So if someone leaves you $100,000 and you have the legal right to it, whether you actually take it or not doesn't really matter. You're entitled to it, so it's going to count against you. And for that reason, you need to be very careful about planning. And I would recommend that in the case of Emily and anyone else in her situation, that she would ask her dad or whoever else wanting to leave her money to create a third-party special needs trust for her benefit. Then this trust will receive the money directly and it won't go through Emily. So third-party special needs trusts. I think nope. We have Jerry's kids next. Okay. So Al has a dad named Jerry. Al is Jerry's kid. Assume that when Al finally gets on Medicaid, Jerry dies. Jerry leaves all of his assets to Al. These assets, again, will be considered available even if Al doesn't want them. So what Jerry needs to do is create a trust in his will for Al's benefit. The trust can provide that money can be used for any purpose to benefit Al, even strippers, at the discretion of the trustee. And this trust then would not be available to Al, provided it was drafted correctly. It's really important that you find a good attorney to draft the will. So, third-party special needs trusts, these are also known as supplemental needs trusts. Supplemental needs trust doesn't really mean anything, neither does third-party special needs trusts. These aren't statutory terms. They're just kind of terms adopted at the preference of whatever individual is using them. So anyway, third-party special needs trust is created by an individual other than the applicant beneficiary. They can be alive, this can be testamentary, it doesn't matter, using money that the applicant or beneficiary is not already entitled to. So we talked about special needs trusts earlier, with the assumption that that money would be the person wanting Medicaid's own money. These third party is someone else's money. The terms of these trusts are very similar to those of the special needs trusts we already discussed, with some important exceptions. It's important that a third-party trust agreement makes clear that no assets of the applicant or beneficiary to Medicaid will be commingled. We talked about how in a regular special needs trust, the state is entitled to go ahead with estate recovery. So you don't want to put your assets in there and then have the state potentially go after the third party money, because the money does not have to be repaid to the state upon death. These assets can be transferred to other individuals. And then there is no age limit, so that the Medicaid person doesn't have to be under 65 years of age to set one of these up. These can be set up by really old people. I've seen like 80-year-olds receive these when the spouse dies. But again, spouses are complicated, so that's a bad example. That is the abrupt end to my presentation. I will try to stop sharing, and then if you have any more questions, I can answer them. I have 15 minutes of battery remaining on my computer, and my plug won't reach to the wall, so we have to wrap up in 15 minutes.
That's always the best excuse, right? Your battery, right? You know,
It is.
like, I really just don't want to be here answering questions all night, so I'm just going to talk about the battery. No, I don't want to take up everybody's time. First of all, thank you so much. If we could, I think if everybody could just raise their hand to show how much they loved this presentation, I think that would be a good example of applause right now. So if you love it, raise your hand. Can you see them all?
Yes.
Yes, it's very exciting. So some people might not be able to figure out how to raise their hand, but they're waving. So I think that's sweet. So all right, now put your hands down, people. Okay. Let's get to the questions. There's also people in the applauding in the chat as well. Can you see the chat, Emily?
It is not open, but I can try to open it now. It wouldn't let me open it when I was screen sharing, but now I might be able to.
Okay.
Okay, yes.
Okay, I bet TK's hand staying up, so I imagine, okay. Okay, I'm gonna let TK ask his question. I have a feeling he wants to ask a question, so. TK, take it away.
It's not so much a question as it is just a comment. That was fantastic. That was better than most CLE programs that I've sat through. So I'd just like to say, well done. Great job. Thank you so much.
Thank you. That's good to hear. I know that we covered a lot of complicated stuff, and I tried to explain it, but I'm sure that not everything I intended on getting through made its way through, but hopefully it was helpful. So
thank you. Okay, I'm going to mute you, TK. I'm going to open up the mic for Bradley. Bradley, you're unmuted. Bradley, go ahead and ask your question.
Okay, so what if somebody won a lawsuit and they wanted to pay off a house and a car? What is the best trust?
It would depend on what assets they already had, I think.
I only have a house and a car. That's it.
So you want to do what with them?
Pay off my house and a car. And I am married.
Okay. So since that's a specific question, that's probably something that you'll have to talk to a private attorney about. But it would depend on what the assets are that you want to put into the trust. Because if you want to pay off the house and car what's the money that you want to pay them off with?
The money I won from a lawsuit.
Oh, then a special needs trust probably, or a pooled trust. It would depend on what your preferences are, and that's something that you could talk about with an elder law attorney.
All right. Thank you very much.
Mm-hmm.
Okay, I'm gonna go to Alana just because I'm gonna go to Jeff last, not because he hasn't had his hand up, but because he's already had a chance to speak. Okay, so I'm going to Alana, you're unmuted, right?
Yeah.
Okay, go ahead.
Yeah, I was just going to actually follow up on what Emily said, because I've done a lot of counseling about that type of question, about if you get a lawsuit settlement, what do you do with it? And I've done both. I've recommended people consider both options. One, to do a 30-day spend down and not bother with a special needs trust or a pooled trust. Is establishing a trust actually costs money. In California, it can cost $2,000, $2,500. And if you already have a debt such as a mortgage on a house, it may be beneficial to spend it within the 30-day window that Medicaid allows you to spend it in. So that's another option. But like Emily said, talk to an elder attorney about the best way to do it. But you have to do it really quickly. You can't mess around and wait for paperwork.
Thank you, Alana. All right, I'm going to let Jeff ask his question. Jeff, do you still have your question to ask?
Well, for the first thing I'll say is I just wanted to say to Emily that she did a absolutely fantastic job on the webinar here, and much appreciated everyone that was involved. I think this kind of thing is just huge for us as a community to start supporting each other and teaching, and these are all the ways that we can sort of navigate this crazy system that we're in. So wanted to give a thumbs up. And then Emily, if this might be something that you write me about later, but I was the one that asked the mortgage question, and my reason, the scenario I had in my head is, if I owned a house here in North Carolina.
Jeff?
Yeah.
Emily's gone.
Okay. Her battery probably ran out.
Oh, no!
Bummer. She didn't get to hear my compliment either. That's so sad.
Oh, that sucks. Oh my God. This is the one thing I can't prevent. I don't know if maybe TK, is there any way you could offer some answers in this or no?
I'll email her because I'll just go ahead and tell you guys what my question was. I was wondering if when I moved to California, if I could transfer the mortgage for my house into a special needs trust, I could possibly have that rental income going into the trust and accumulating for me in a way that would really help me out. But I don't know, when I mentioned the mortgage, she was like, "Ooh, that's way complicated." So I probably just need to write her privately.
Maureen, are you able to answer that? I know you're in a situation similar to that. Maureen Donahoe?
I'm going to unmute.
Well,
Hey, Maureen.
hey, yes, I do that actually, Jeff.
Okay, awesome.
And this stuff is so confusing to me that I think it goes into with self-settled trust.
Okay, yeah.
Yeah, that's what it's called. And, I want to clarify, it's not the mortgage that's in the trust.
Right, it's the asset, yeah.
Yeah, it's the property that's in the trust.
I just didn't know how the mortgage might confuse things, because obviously the bank holds the title, when it's under mortgage, and I'll probably contact an attorney as the answer, but I just wanted to know if it was even worth bringing up to an attorney. It sounds like it might be.
The title goes into the trust.
Yeah, okay.
And,
Nice.
And so out of your name.
Okay. Yeah, that's kind of what I was thinking. So I'll bring it up. Thank you. That at least lets me know that it's possible.
Are you definitely moving to California?
I'm working very hard on it. Yes, sir. Yes, ma'am.
Because there is a special needs attorney.
Okay.
Stephen Dale, but he's very expensive.
Yeah, I gotcha.
Yeah, he costs minimum $2,500.
Yeah,
Like-
it's a very expensive thing.
Right.
Yeah, it is.
I know my dad is offering to set up a third-party special needs trust for me. Yeah, for the mortgage thing, I might have to do a first-party trust or, self-settled like they were talking about. But at least I know that it's a possibility.
Yes, it is.
Okay, awesome.
Amanda is online, and she was writing in the chat box, and I don't know if the folks that are left can answer this. I know I can't, but so she said she kind of watched a little bit about the third-party special needs trust. She said, my father's in the military. He took out something that would help me or would pay me his retirement upon his death. Would I need to get him to set up a third-party trust to protect me from having too much money? Can he do that even though it doesn't take effect until he passes?
Yes.
Okay. And TK, would you mind sharing a little bit about your trust? Didn't you set up one of these things?
Well, actually, my father set it up in his will, and so when he passed away in 2012, I became one of the executors of the estate. So my sister and I are responsible for taking his property and then conveying it. So in his will, that's what Emily was talking about, a testamentary trust. The will created the trust itself. And so basically he only had one asset, which is a valuable piece of property up in Cape Cod. And we had the house on the market for the last 3 years to sell. And so we haven't sold it yet. So other than that, we're kind of in limbo. Technically, the state of New York is probably going to track me down and say, what the hell's going on with your trust? But the fact is, there's no money because we haven't sold the property yet. And basically, all I have is, the trust has a half ownership of this property that is just a real drain. So we haven't conveyed the deed. We haven't conveyed anything into the deed, and we've been just into the trust. So we've been in sort of a state of limbo for 3 years. But unfortunately, it's not as much of an answer as you guys deserve.
Well, thank you for trying. I mean, I didn't know. It kind of makes sense. And I mean, so I
would say one thing, like the selection of the trustee is really important. My father told me when he was going to set up the trust in his will, and he asked me if I had any suggestions of who would be a good trustee, because one thing you want is you don't want an older person being a trustee. You want somebody that's going to be young and be around for quite a while. So I picked a friend of mine from law school that doesn't know anything about trust and estates. And basically my game plan is I'm going to do the work for him, and he is somebody that he is an attorney. He knows what, he's willing to listen to me, and he respects me. So in the end, it will work out, but it's a pain in the ass.
What happens if your trustee dies?
I forget whether there is a backup trustee or the court would appoint a new trustee. And I would have, at that point, I would have my sister be the backup, be the trustee.
I guess it's probably good to just have that in place, like have a backup for the backup for the backup.
Absolutely.
And don't put them all on the same plane.
You mind if I add something here?
Yeah.
Can you hear me better now?
Yeah. Which one? Who's talking?
This is Blake.
Oh, hey, Blake.
Yeah.
Okay.
Yeah, I was just gonna say, me and Matt, we have sort of you know, an interesting arrangement because we our mother's we'll have a testamentary third party special needs trust. So and you know, regarding trustees, we there's going to be 2 trusts. There's going to be one trust for me, one third party special needs trust for me, and one for my brother. So, and the way we did this is like I'm going to be the trustee of this trust, and he's going to be the trustee of my trust, and then and apparently, even though that sounded to me like it shouldn't, like it might not be like exactly like it sounded shady to me, but the lawyer said it was fine, so I don't know. But
It'll work. It'll work.
but we were able to choose like as many backup trustees as we like in I think it might be written in the I don't remember if it's in the trust paperwork or the will, but in one of those things there's like I think we named like 3 deep trustee backups or something. We had it like super covered just in case, you know.
No, I think that's smart. I think that's really, really smart. As just a side note, a commercial break maybe, I don't know what you'd call this, but my lighter that was recommended on Living with MD just arrived. Now, I don't use it for illegal stuff. I just want to light some candles. But I just lit this thing and almost set my face on fire because I was not expecting it to work as well as it did. Sorry, just thought I would share.
Can it show us?
Okay. So, oh God, and it gets kind of vibrating and weird. Okay, right now it's like hissing like a snake, and then I just hit this button, and it stays on and holds, and then I have to shut up. Shut. Whoa.
Like a little jet engine.
Huh?
It's like a little jet engine.
I know, it is. It is. It's like a little jet engine. Okay, that was just a side commercial note on the lighter that Allie Kitty Legs Pierce recommended. Okay, anybody else have any other questions for Emily that's not here?
Actually, I gotta get going, but this has been great.
Thank you very much, everybody. I posted a link to the NMD United feedback form in the chat. Please fill that out for us. It really helps us with our numbers. We're going to be applying for grants in the near future, and that will help us with our numbers and our overall reporting. So I would really appreciate it. I will post it one more time in the chat, and I will also post it on Facebook as well. Anybody else have anything to say before we go? I think you can unmute yourselves.
Awesome presentation.
Thank you.
Yeah,
Thank you so much for doing it.
No problem. It was good seeing everybody.
see you online.
It was really good to see you guys. Oh yeah, tomorrow night's Parenthood. Journey to Parenthood. Okay, with
Awesome.
Corey Jacobson. All right, good night, you guys.
Night.